ineffective assistance of counsel. The lawyer that you have hired or the lawyer that was appointed to you is required to do certain things. There are certain things that are a lawyer's decision, and there are certain things that are your decisions. A lot of clients and a lot of individuals that are facing criminal prosecution do not understand which decisions are theirs. For example, the decision for you to testify at trial is your decision alone. It is not a decision that your lawyer makes for you. Your lawyer may suggest that, but ultimately it's your decision as to whether or not you want to testify. The decision as to whether or not a jury sentences you or a judge sentences you is your decision. It is not the decision of your attorney. The advice that your attorney provides and the way that the attorney provides that advice can make a huge difference in your decision-making process. So you always need to make sure that that decision was solely yours and not the decision of your attorney because your attorney decided that that was the best strategy to use. The most common mistakes or the most common issues that come up on ineffective assistance of counsel, I would break them down into several primary issues, would be failing to investigate either witnesses or specific evidence in a case, which is failing to interview witnesses and failing to pursue certain evidence that could have been exculpatory. There could have been missing plea offers or failing to communicate specific things with a client and not filing key motions to suppress, not objecting to certain things that may have been prejudicial throughout the course of your case, or even potentially issues that may have come up on appeal. The complexity behind ineffective assistance of counsel really stems with the Strickland standards, which is the seminal case on ineffective assistance of counsel from the Supreme Court, the United States versus Strickland, which is primarily focusing on two separate factors. One was whether or not your lawyer's performance was deficient, and the second being whether or not that deficiency was so high that it prejudiced you during the course of your case. In Texas, we have two separate phases of trial. First phase being the guilt-innocence phase, the second phase being the punishment phase. Your lawyer can be ineffective at both or in one of those phases. Many times what we have is a lawyer was primarily ineffective during the punishment phase because during the punishment phase, there are so many things that come up with respect to how a judge or a jury ultimately views you and considers the course of punishment that is appropriate for your case. The objective approach in that can become highly controversial because there are issues that your lawyer may have failed to take into account for purposes of mitigation, which your lawyer is required to do.